Hi, well, good evening, everybody. Welcome to the third of our autumn/winter series of webinars. This evening, we're going to cover the right legal relationship for your farming business. Clearly, lots of times the legal niceties of what we do and don't do are not top priority, but it's really important that we get these things right, and we're lucky enough to have Tim, Russ and Julie Robinson with us this evening from Roythornes, who are big supporters of the TFA and experts in this field. So it'll be interesting to hear what they've got to say. And I think, as we're all pretty much aware from the announcements on Monday and the sort of build up to those, that things are changing, and we're going to have to be on the ball. We're going to have to make some changes to our farming systems, and no doubt there will be some legal niceties around what we can and can't do, how we make sure we can enter the new Elms world in a seamless manner, and how we make sure that we're well protected. So it's a pretty timely point to have this discussion, I think. Just a bit of housekeeping. The advantage of Zoom is we don't have to go through any fire checks or anything like that. So if you hear a fire alarm, it is a real thing, and somebody's going to disappear and run out of the house. So, but apart from that, the webinar is being recorded and can be viewed after the event on our YouTube channel, and will be available via our website. I've also a big thank you to Barclays for once again sponsoring this series of webinars. Barclays are a big supporter of ours, as many of you will know, and it's really good of them to do that and help us with their sponsorship through this program. So I hope you're all settled down, looking forward to it. I don't know what the weather's been like for the rest of the country, but we've certainly had a very beautiful November day, in stark contrast to any single November day we had last year. So it's actually, for the first time in about 12 months, a pleasure to be able to walk around the farm these days. So I think we're just about at 7 o'clock. So we will get started, I think. So I've already introduced Tim and Julie, but our first speaker is Linda Davey from the GRP, well, from Marshall Wooldridge, who are part of the GRP group. Many of you will know that during the course of this year, the GRP group have taken over the TFA insurance scheme and policy, and we're very pleased to have got this relationship going. And those of you that were on the first webinar, I'm thinking about a month ago, I'm not very good with my time, but about a month ago, we had a very good introduction to GRP. Linda's going to talk us through a little bit more specifically, I think, a little bit about GRP, obviously, but also about farm safety, health and safety in particular. Linda's from a farming background, has had 33 years, I think I read. You don't look old enough to have had that, Linda. But you've clearly got a lot of experience in this field, and so it's very, very good of you to come along tonight and to talk about health and safety. It is one of the least pleasant things that I have in my role as national chairman, which is to get frequent emails from the health and safety executive about tragic accidents that are happening on farm, which are all too common. So we all need to be aware of that, and I will let Linda talk about how we need to be on top of health and safety. So over to you, Linda. Welcome. You're on mute, Linda.
There we go. Can you hear me now?
Brilliant. Yeah, absolutely.
Right. Sorry about that. Okay, so I'm Linda Davey, work for Marshall Wooldridge, part of the GRP group. Thanks for having me on today. Some of you may have seen my colleague the last time we had a webinar. She was called Debbie Airy, and I work very closely with Debbie. I've only been employed by Marshall Wooldridge for a very few weeks, so you'll have to forgive me and be gentle with me tonight, but I've been brought in basically to handle or to assist in handling the increased farm portfolio that we have. I've got a very long history of dealing with farm insurance that I think Mark's already pointed out, far too long to remember. It includes a long time on the claims side, 13 years in claims and 17 years on farm exec side. So I have seen both sides of the coin, from the claims side and the underwriting side. So got a fair bit of experience behind me, and Debbie and I just work together to try and improve things all the time, because the information, unfortunately, coming across from Henderson's hasn't been the information's been there, it's just been coming across slightly late. So that is improving all the time, and going forward we want to make this an exceptional relationship. So yeah, my job to talk about health and safety on farms, it's something that I'm pretty passionate about. I went to a seminar last June, in June 19, before the COVID stuff started, and there was a very interesting speaker there who was from a firm of solicitors, who gave us some fairly stark facts about the accident rate on farms. At that time, which I say was June last year, he said that 1.2% of the UK workforce is employed in farming, but farming accidents are actually 20% of the entire accidents in the UK. So that is disproportionately huge. There are 30 fatalities a year approximately, and all that needs addressing. And there are things that we can all do to help get the farms and get you involved in making the farms as good as they can be, to try and make sure that you are compliant with all the regulations, and also just to protect yourselves from accidents and make the farms as safe as possible. You're probably aware that if health and safety get involved on a farm, they can charge an awful lot of money. There's criminal prosecutions that can result if you've breached any of the regulations. And they can charge, I think the latest figure last year was around about £150 odd an hour just to investigate and report on any incidents. So you could end up just with a massive bill to pay because they can charge you for all the reporting and investigation, just for looking around your farm and deciding that there's things for you to address. So if you get ahead of the game and there's nothing for them to worry about, then you're not going to be faced with a large bill. So there's two things briefly I just wanted to touch on tonight. The first is that we do have a product that is our farm risk portal. It's not an involved risk assessment. It's not a complicated thing to do. It's a very inexpensive way of getting hold of a lot of information, doing your own risk assessments because the documents are all there for you, doing self-assessment works. There's lots of information there on Brexit and how that might impact on regulations, and also COVID safety is on there as well. There's lots of e-learning courses on there, which you can take the papers, which give you certificates in things like asbestos awareness, first aid, confined spaces, electricity. There's a whole load of certificates that you can learn and pass, which will enable you to have a paper trail for any investigation that may or may never happen. But at least if you've got it all there and it's all online, it's all documented, you've got a portfolio that you can build up just specific to you. So this particular online portal is something that you can buy a year, buy for a period of 12 months. It's very competitively priced. It's just a tiny £50 a year. So that gives you, is all aspects of health and safety, gives you human resources as well. business continuity, and all the up-to-date documents and information that you may need. You can download a lot of it, and you can also ask an expert on there as well. So it's a really comprehensive portal that you get a login for, and you can access as much as you like and do as much or as little as you like. For £50 a year, it's pretty good. So that's available, and if you want any more information, we have leaflets on it. There was supposed to be a slide tonight, but I don't think my slides have sort of come through, unfortunately. But we have leaflets that give you a brief summary of what it's all about, so you can decide if it's for you. The second subject I just wanted to talk briefly about is engineering inspections. Again, part of the regulations that we have to think about are the lifting equipment regulations, Pure and Lola, and in order to comply with those, we offer, again, a very competitively priced engineering inspection, which is very simple to use and comes in 2 different categories. So you can have up to 2 machines, any 2 machines, anything you like on the farm inspected, or up to 5 items, anything. Don't have to name them in advance or get a price in advance. It's just a set figure for 2 items or 5 items. The inspectors are familiar with what they might expect to find on a farm. So it might be a teleporter, it might be a compressor, it might be some sort of lifting equipment like a hydraulic lift. But the 2 items are £172.41 plus VAT. And up to 5 items is £275.86 plus VAT. Again, pretty competitive when you look at what else is out there. And for that, you get all your certificates, you get a list of anything that is potentially likely to go wrong. So in other words, it's past this time, but it looks like there's a bit of wear and tear, could be a problem in the future. So it helps you get ahead of the maintenance on your machines because you know what's there to be done. And it ticks the box for the health and safety executive if they come round and say, where's your lifting equipment certificates? Because I understand that is one of the first things they ask, especially if there's an accident on your farm that involves the lifting equipment. That's the first thing they're going to ask for. So if you want to maintain your equipment and show that you've maintained it and you've got the certification available, and keep the value of your machine, because if you're ahead of the game on anything that might go wrong, it's going to maintain the value of those machines. So there's lots of reasons to do it. And if you want any advice or any information on that, the engineering inspections, I'll gladly send you any leaflets that you need. You can contact myself or Debbie Airy. And that pretty much sort of covers what I was going to say about health and safety. It's something we're all frightened of, but I think if we've got some kind of evidence that we've taken as much precaution as we can, then I think health and safety executive are likely to look on you as a proactive type of person who is likely to do what they want you to do, rather than hiding things or not being able to show that you've done everything you should do. It's very easy when time's tight to just roller coast over it, but you'd be aware that health and safety did start a very comprehensive tour of farms at the beginning of last year, and even through COVID, I understand that is still going on, maybe not as intensely, but someday when COVID is over, they're going to pick up the pieces of that and carry on the very intense program they've got of inspecting farms. So whilst they might announce themselves now, they might not in a year's time, when COVID's over and done with and they don't have to take COVID precautions. So I hope that you might take up some of the things I've suggested. And if you do, I'd be happy to talk anything through. But as I say, please be kind to me with any questions, because I've only been here a few weeks. Thank you.
Thank you very much, Linda. Thank you very much. I should have said, a bit remiss of me, if you have questions for any of the speakers, please put them in the Q&A box at the bottom of your screen, which you should see, and we'll ask a few questions as we go through, and there will be time at the end to ask questions to all of the speakers. Linda, before we move on, I just a couple of questions, I guess. Interesting about the portal and having the paperwork in order. I think that's something that does sort of frighten us all a little bit, is the amount of paperwork that goes with it. I just wonder though, would you recommend that we encourage not necessarily the health and safety executive themselves, but experts in that arena to visit our farms to give us recommendations of what physically we should do? Because I always worry a little bit that people will have all their paperwork in place, but the reality is they didn't have the physical stuff in place. So that's why the accident happened, and that's the issue. So would you recommend we encourage people to come on farm and make recommendations? And do you?
Ideal world, that would be the thing to do, is to get a professional risk consultant in, but the problem is that comes with a huge cost. I mean, you're looking at, I would say, somewhere between 1,500 and 2,500 to get a full risk assessment done by a professional, and whilst that would give you a very bespoke portfolio of risks and what you've done about those risks, not everybody can afford that sort of cost. So this is why we've tried to come in at the very lower end of the health and safety consultancy and say, look, some of this you can actually do yourselves, and there's all sorts of prompts and information there to give you an idea about what you should be looking at. So it guides you really, and it's never going to be perfect, because the portal is not going to be able to see the farm, so that's not going to be they're not going to identify absolutely everything, but it gives you a fairly comprehensive idea about things you should be looking at. And I think that's what health and safety executive want to see. They want to see some sort of proactive measure taking to make sure that you're doing something and not just sitting there waiting for the accident to happen. So I think if you can afford to do it, yeah, great. Spend your $2,500 and get your consultant in, but that's not always possible.
Okay, and I guess in terms of cost, from an insurance point of view, are we likely to get cost reductions by having up-to-date health and safety information and the proper risk assessments and all the tests done, or is that a given? And I have a sort of a ride-on question on cost there from one of our members, Michael Summers, who says that engineering inspections are fairly commonplace on farms, but lots of other insurers don't charge a fee. Why is that not? Why do you charge a fee, I guess?
Sorry, for engineering inspections, they don't charge a fee?
Yeah.
Really? I don't know of any, unless they build it into the cost, because there's always going to be a cost implication to get a professional out to the farm and to inspect the machine and provide the correct certificate. So whether they identify that cost separately or it's built into the package, I don't know, but we would identify that separately so that you know exactly what you're getting, and there's no hidden costs.
Okay, thank you. Okay, thanks, Linda. That's really interesting, and I think the first statistic that you raised there of 20% of the accidents is something that we all need to consider and bring down. We do a lot of working in loan environment, and health and safety is really important. So thank you very much for that, Linda. And any other questions for Linda, to keep firing them in, and we'll pick them up later. So we'll just move on to Julie Robinson and Tim Russ from Roythornes, who are going to cover the sort of legal side, legal relationships of your farming business. So if I hand over to Julie, if she's not on mute, that's great. And we'll look forward to it. So any questions for Julie and Tim, just put them in the Q&A and we'll pick them up after this session. Thank you.
Well, thanks very much, Mark. And hello, everybody, wherever you are. Tim, Russ and I work for Roythornes, and we spend a lot of our time, actually, when I think about it, an awful lot of time doing landlord and tenant work and doing work on alternative arrangements for farm businesses. We know what we mean: contract farming, share farming, a range of joint ventures in between those two, and some dodgy stuff as well. Basically, Tim has been knocking around for quite a few years now, Tim, and is an experienced litigator. So he sorts out the disputes. If there's an argument, that's where Tim gets involved. I get involved trying to set things up well enough to avoid arguments. Okay, that's my job. So we come at this from two different angles. And if I've done my job properly, Tim would be out of a job. So let's have a look at what we're going to do in the next 20 minutes. We're just going to have a look at a key concern I know for a lot of TFA members is what their tenancy agreements say about what they can and can't do in terms of bringing others onto the land to do stuff for them, whether it's contractors, whether it's graziers. So we're going to have a look at that. Then we're going to have a quick look at the distinction between contract farming, as we know it, and share farming and other JVs. Fundamental distinction that matters for tax and for other purposes, for BPS, etc. And then we're going to have points to watch for in contracting agreements, and then points to watch for in share farming agreements, really based on what the conversations that I've been having over the last 2 months, and very much around what we see as an uncertain policy landscape at the moment and how we're dealing with those, and not just having annual agreements that leaves everybody, having to think every year about how to renew. So how to have long-term relationships backed by an agreement in an uncertain policy context. Okay, well, I'm going to bring Tim straight away with some rather typical, you recognise them, tenancy agreement clauses and and how much they restrict the tenant with what he can do. So Tim, if I take an old style, what we would call an alienation clause in an old style AHA tenancy agreement, very simple, it just says not to assign, underlet, or part with possession of the holding or any part of it. So in your experience, Tim, what can and can't the tenant do?
Okay, thanks, Julie. Well, good evening, everybody. Well, this is a fairly typical old style clause, as Julie said, and it doesn't prevent sharing of occupation. So with a carefully constructed contract farming agreement, the landlord would have some difficulty in arguing the tenants in breach of the clause. The things to watch out for are, the first problem is what lawyers call parting with possession. You need to be careful under the terms of your contracting agreement, you're not parting with possession, because as Julie read out the clause, it prevents you from parting with possession. Parting with possession really means effectively that the person you've parted with possession to is really in complete control of the holding to your exclusion. So if you're having a contractor claiming the basic payment scheme payments, you might be in difficult territory, because if you look at the scheme guide, it says you can only claim it if you're in possession, and a landlord will latch on to that if there's a desire to engage in a program of tenant bashing. If you part with possession, it's what's called a case D matter. It's a remediable breach, so you'd have to get a notice to tell you to sort it out. But obviously, if you've just got yourself into a nice contracting arrangement and you've had a notice to, which is a precursor to a notice to quit service, it's tedious to sort it out and also potentially expensive. There's a risk that a grazing agreement could be construed as an underletting if you get that wrong. And underletting is a case E matter, so that's much more serious if the landlord can show material prejudice. You want to make sure that the documentation is in place which restricts the grazer's rights. He's given permission to use the land and take the grass. And also watch out for other clauses in the tenancy. There may be something that restricts your right to have other people's livestock on the holding, or effectively to agist livestock.
Great. Okay. Thanks, Tim. And presumably on that contract farming point, and if the landlord did get shirty about parting with possession, if the contractor was in effect, basically running the holding, you may end up in breach of your contract farming arrangement if you get a notice to remedy. Yes. And you need to get your contractor out, and you haven't got the rights to end the agreement there. I mean, presumably that's the sort of stew people end up in.
I mean, these are all extremes, but all lawyers who've been in practice as we have long enough know that you prepare for things that are never supposed to happen in the documents, and then they keep happening all the time. So that's why to an extent some documents need to cover all the bases as yours too, I think.
So well, I hope so. But I'm just thinking about that point about where tenants have contractors now, and wondering whether my agreements do. I think they do, yeah. Now then, if we look at another slightly more modern clause, we find that the newer clauses are tighter altogether. So this is from an FBT. The tenant shall not assign, underlet, charge, part with, or share possession or share occupation of this lease or the holding, or enter into any or grant any right or license over the holding in favour of any other person. I think that probably knocks contract farming and share farming arrangements on the head, Tim, never mind potato growing licenses.
You'd have to get consent, and it would also cause a problem if a partnership was in occupation and you hadn't got consent for it, because that would be a breach. And I've done an arbitration on a clause very like this, where if the tenant hadn't have done a deal shortly before the arbitration award, he would have been out. So because he was basically ignoring the sharing of possession part of it. All the rest of it's pretty easy to get around. It's the sharing of possession is the problem.
Yeah, okay. All right, so just watch this, everybody. If you want, put the worry on your lawyer, and certainly I end up losing sleep over these because I get agreements to have a look at, and the tenant farmer says, what can I do? And within my alienation clause, and we need to be very careful. The answer is, often an old style clause will allow you to enter into some kind of contracting agreement. We need to be careful. We need to make sure it covers all the bases. I am doing contracting agreements for tenant farmers, and I'm doing very popular are what we call crop purchase agreements or crop supply agreements, where the contractor buys the crop from you and grows it on your behalf. They are risky. They cause me a lot of stress, but they're very popular and clients like them. So we've done a lot of work with agents on these to make sure that they're not simply an exchange of invoices, but to make sure there are some variable payments, variable prices, and to make them look and feel much more like a traditional contract farming agreement. Anyway, let's move on and let's have a look. I just want to just quickly have a look at contract farming versus share farming, just as a fundamental distinction. And then I'll bring Tim in again. But under a traditional contract farming arrangement, where, if you're the freehold owner, if you're a landowner, your drivers may be different. They may be stepping back, wanting to keep the capital tax advantages of trading as a farmer and of being in business. And if you're a tenant farmer, your motivation might be different. It might be a need to step back, a need to stay in the farmhouse. But whatever the reason, a contract farming is going to look pretty much the same, whatever the principal motivation is. Basically, if you, at its base, if you think window cleaner, you're not far off, okay? So you engage a window cleaner to clean your windows. And if he starts taking your panes out and replacing them, you're going to say, what are you doing? And he's going to say, well, it was cracked, so I thought I'd replace it, and I'll charge you for it afterwards. And it's fundamentally a contractor is acting under the direction of the farmer and under the control of the farmer. He's not running the farm, okay? And he's working on the basis of the terms of a farming policy, which you have designed, and you have decided what will be cropped, what will be grown, what will be reared, when it is sold, etc. Now, it may be obviously at the beginning of the agreement that you will agree, the contractor obviously needs to know what he's doing, and you've engaged him because he's an experienced contractor and he's going to have input into the how a lot of the time of the contract farming agreement. But fundamentally, the contractor is carrying out your farming policy. If he's buying inputs on your behalf and paying vet bills, he's paying them on your behalf. He's not paying them on his own account. Actually, he's not paying them on his own account and recharging you. He is paying them with your authorization and as your agent, which is a fundamental distinction in law, that agency. And so the contractor is acting as your agent. And Tim mentioned that idea in a contract farming arrangement of a contractor being the basic payment scheme or subsidy claimant. And this is it's a difficult one, because I wouldn't expect the contractor to be the BPS claimant, because to be a BPS claimant, you have to have management control of the holding. And I would expect the farmer to be the one with management control of the holding, because actually that is what he's going to either say that to the taxman, his estate are going to say after he dies that he was actively farming that holding and occupying the house for agricultural purposes, for purposes of directing the farming. Or if his landlord comes and says, you've sublet this, he said, no, I haven't. I've just got someone carrying out operations for me. I'm not in breach. Well, why are they claiming the BPS then? So I simply wouldn't expect to see it in a contract farming agreement. I would expect to see the contracts in the name of the farmer, not in the name of the contractor. I would expect to see the livestock records in the name of the farmer and not in the name of the contractor. Doesn't mean there can't be, sometimes the contractor will bring some livestock onto the holding and will bring cows onto a holding, in which case we'll probably have a cow hire agreement behind that, where everything again gets run through the farmer's account and settled through the division of net surplus in due course, with a separate hire payment going off to the contractor. So that idea of that contractor bringing livestock onto the holding and hiring it to the farmer takes me to the second option, which is share farming, which is something just fundamentally different, because in share farming, both parties are carrying out the trade of farming. In contract farming, only one party is, and that's the farmer. That's the landowner or the tenant farmer that engages a contractor. In share farming, both parties get the tax advantages, reliefs, averaging, etc., that comes from trading as a farmer and operating an agricultural business, and so that is a very different animal altogether. And it is the beauty of a share farming agreement, is that we don't need the landowner or the tenant farmer who's wants to work with someone else. We don't need them to be holding the contracts. The contracts could be held by either party. The inputs could be bought by either party. The land can be provided by either or both parties. Really, a share farming agreement is a very, very flexible arrangement, and I do a lot of them. I do a lot of them in horticulture, and I do them in dairy, not necessarily for new entrants coming in, but I do them to solve a problem usually, which is that the contract's in the wrong place for it to be a contract farming agreement. So we set it up as a share farming agreement. And then what we get are some other arrangements as well, which are just joint ventures. They're nothing to worry about. They are simply, it's not quite one and it's not quite another arrangement. And if I give you an example, it would be where we have an expanding dairy business. Basically, they're looking for places where they can house their cows. They've got the milk contract. They want places to house their cows. They want there to be a grass platform somewhere that will enable there to be some forage provided on the farm. Maybe they want some labour on the local unit. And so what we'll often, it's not a contract farming agreement, doesn't really work like that, because the milk contract is with the contractor. Skills are with the contractor. We've got some skills with the owner. So the owner's got some forage kit left, used to be in dairy farming himself. So what we do is we simply do a dairy joint venture. And it's neither what there's income going into the landowner is getting income in via the joint venture, rather than as the contract holder of the milk contract. Okay, lots can go wrong in that if we don't cover off all the bases and be meticulous. The key thing is to walk through whatever arrangement it is, just to walk through and stress test everything in the arrangement and try to think, as Tim just said, try to imagine what might happen. And I think, Tim, I think you were telling me you've had an experience, a topical experience, COVID experience, where an arrangement hit problems because the contract farming agreement didn't have the flexibility it needed. I think it was a dairy arrangement.
Had a dairy farming business where they are contractors actually running the dairy farming, and the milk purchaser was one of the milk purchasers who suddenly decided they were going to cut the amount they were attempting to take from the farm, and not for seasonality, but purely because the market had fallen away. If there's no relationship, as there wasn't or no documentation about who bears that loss between the farmer and the contractor. The contractor was saying, this is the number of animals I'm milking and I want payment for them, please. And I don't really care that you can't sell it to anybody. Very short-sighted view, of course, but that's what he was saying. And there was no mechanism to downsize the herd in the contracting agreement, which was pretty skeletal. So, I mean, the end sense, there was some sense came to that because the parties wanted to continue the relationship, but it would have been very easy if there'd been an arrangement put in place in the documentation that anticipated this. And as I say, the longer you practice as a lawyer, the more that things that are never supposed to happen keep happening with monotonous regularity, and therefore the agreements need to cope with them. So there we are.
Okay, so that brings me on to what to look out for, what to watch for in your contract farming agreements. Very quick, hold on to your hats, everybody. Here we go. All right. These are issues that I've just been discussing, even today, yesterday, the day before, that as I'm doing the late agreements for Michaelmas that were due to start at Michaelmas, but there we go. And so one of the key points for me is to be absolutely crystal clear in both contract farming and shared farming agreements, who does what and who pays for what. And more I'm doing a really more and more detailed schedule, because it's useful for the parties because they think it through and do this walkthrough exercise. But even down to waste removal and different types of waste removal, dead stock removal, oiling the gate, and that comes from the grouses that I get about an owner will ring me up and complain about his contractor, and I say, what does the agreement say? And nobody knows, so they just feel bad about it because they haven't really dealt with it and thought about who was doing what at the beginning. So particularly where you've got your net surplus, your contract farming agreements based on the division of a net surplus, you want to be absolutely clear about what costs are in there. Software licensing costs, big issue these days, agronomy, haulage costs. I remember parties falling out because transport to store hadn't been covered and the contractor ended up doing it and it took his margin away. And it's quite normal in a contracting agreement for the tenant farmer, the holding owner, if you like, to want some of their track maintenance and infrastructure costs catered for within the division of the net surplus. But a cap will usually be agreed on that, or a percentage of the income in will be agreed for that. BPS in or out, big question. I know there are some agents as well listening, a big question as to whether BPS is in or out. Usually a landowner may take the view, let's have it out of the agreement, let's focus on operational farming, on the cropping, and see what the net surplus is from the cropping. And landowner simply takes the BPS. It's just factored in, because then at that point the contractor will want a better element of the net surplus. With BPS now reducing, the debate is quite a live one, because obviously landowners, if secure, BPS income is going to fall as well, and he's going to, want nonetheless to see some kind of rent, in inverted commas, some kind of steady income coming in from the fact that he owns or has the right to farm that particular holding. Stewardship, often that will be out with the contractor being paid to do some work. as and when needed. But I think with elms, and I'd be interested to see what George thinks on this, I do think with elms and with, we hope, most farmers taking part, that actually there'll be a different discussion between the landowner and contractor on environmental schemes, because they really will be almost joint ventures between the two. Both parties will be needed for successful delivery of those. How are losses dealt with? Basically, landowner or the farmer should be taking the loss in a contract farming agreement. If there is a loss after you have paid costs and everything, and we saw that last year with earlier this year in the arable sector, worrying about there being losses, that should lie with the landowner, really. Otherwise, he doesn't get a guaranteed return. He's an active farmer. If he was farming in hand, he wouldn't get a guaranteed return. That's how, when you look at the agreement, that's how it should look. What is the farm? What is the herd that is being contract farmed? Tim mentioned that. You need to allow yourself flexibility, not just for force majeure events, but in any event. You need to allow yourself some flexibility to change the area of the holding, the fields, the cropping. Sorry, well, I just get a drink. So that's really quite important, to give you that flexibility. Otherwise, you'll be tied into something for quite a long term. Usually we allow some percentages of reductions in the area, because of course the contractor wants some security. He's investing too in people or kit to be able to do the work. If you if you are have employees and have housing, that needs to be looked at as well. Watch for 2P. That's on contract farming. Tim, anything from you to add on contract farming in your experience?
I don't think we've got enough time, Julie. We're a bit
yeah, no, exactly. Share farming, key point for me is to make sure that you're dividing gross outputs, because if you don't divide your gross outputs, you will be dividing your net results, and there is a risk of a general partnership arising at that point. And if you're in general partnership, there's a different kind of liability between the two of you arises, which Tim will leap in and explain for you.
You're all jointly and severally liable for each other's debts, so it's not a good idea unless you want to engineer that.
That's very good. That's it. You don't want to get into that relationship unless you want to be in that relationship. So you need to find a way to divide up the gross outputs. You're actually sharing the crop. You're sharing the cost of the inputs. How you do that is one for the agents that I work with, and then we set it all out in the document. Okay, that's everything really from me and Tim for now. It's sort of a whistle-stop tour. There's lots to say that'll maybe come through in the questions. Thanks. Back to you, Mark.
Brilliant. Thank you, Julie. Thank you, Tim. Yeah, absolutely. A lot. You covered a lot in there, and I'm sure there will be some questions afterwards. There is a question here which I'm gonna start Caroline's. I'm not sure I introduced Caroline at the start. I've been a bit shambolic, haven't I, with my introductions today? Apologies for that. Caroline is one of our advisors at the TFA. I'm sure many of you who are on the call will have got some expert advice from Caroline over time. And Caroline is just going to give us a little bit about the importance of a written agreement. So I'll just throw this comment from Charles Skelton at you, Caroline, and maybe you can answer this one. Charles says, surely a simple combinable agreement on 300 acres doesn't require a formal agreement. What could possibly go wrong?
I did see that one pop up, and I thought, well, that's essentially the basis of what I'm going to talk about. So perhaps I'll, if unless there's more questions, I'll rattle through what I've got to say about the importance of having. No,
you go for it. I thought it was a relevant starting point for you.
It's a good, great introduction segue into what I've got to talk about. So I'll, as Mr. Skelton says, what could go wrong? Well, I'll give you some examples perhaps, and if the question still stands, I can answer it at the end. But what I've got to say, as Mark says, I'm Caroline, advisor at the TFA, and I'm just going to follow on from what Julie and Tim have been talking about, more to stress the importance of more generally getting things put into writing instead of relying on verbal agreements. So everyone knows where they stand from the off. And as the title of this webinar suggests, it is a legal relationship, whatever the type of arrangement you might have. So it needs to be treated that way as such on paper. So as a TFA advisor, nature of my role, more often than not, speaking to tenants who do find themselves, unfortunately, in dispute with their landlord. Disputes that could be are most easily resolved, obviously, where there has been a record of what's been agreed, whether that's in a tenancy agreement, another type of contract, whether that's contract farming agreement, share farming agreement, even if it's just in correspondence or otherwise just in writing somehow. It's always just much easier to resolve these issues if there is a record somewhere. But unfortunately, I am so often finding myself advising members who don't have a formal record of what's been agreed, and it can make a dispute which would have otherwise been very easy to resolve, almost impossible to resolve in some cases. So it's vitally important whenever agreeing anything to document it in writing. Where we're talking about the occupation of land, firstly getting the correct tenancy or other agreement in place at the beginning of the relationship is vital. As Julie and Tim have talked about, there are a few different options depending on your circumstances, and so it's equally important to get the right type of agreement in place. Also, as Julie and Tim quickly touched on towards the end of their talk there, you also might want to avoid, in some cases, having a sort of statutory provisions kicking in and having a different type of agreement in place, or partnership, for example, that you actually don't want in place, and you want to avoid that. And to do that, put what you do want in writing effectively. So agreements that I come across where there might have been an issue, they're so often made face-to-face at meetings, things are discussed and agreed in text messages even. And although when everything's running smoothly, parties might feel they can rely on this, they have trust in each other to keep their word. It's if the relationship breaks down or there's a misunderstanding of what was actually agreed, without something in writing, both parties can be left quite vulnerable, especially where investment has been made, or the parties are relying on that verbal agreement that's been made. So a lot of what I've sort of made notes to talk about is from a tenancy context, but just thinking about contract farming and Mr. Skelton's query, that investment doesn't necessarily need to be in a tenancy context in terms of fixed equipment. It could be a contract farmer making that investment in putting the crop in the ground. If he's got no written agreement for any assurance of what he's going to get in return for that, then he could be very vulnerable, as I say. So although I'm coming from a tenancy angle, this is very much still relevant to contract farming, share farming agreements, any kind of agreement really. And it's not just that initial agreement that needs to be documented. Also, when any changes or additional agreements are made throughout the arrangement should also be put into writing. Sometimes it doesn't have to be a formal agreement, especially when it's a change. It could be put into a letter, for example, could be a memorandum that's just appended to the original agreement. Some more legal alterations might need to be executed more formally as a deed, for example, but at the end of the day, getting anything just put into writing to keep a record of what's been agreed is a good start. And it might not appear, as I've said before, might not appear necessary when everything's running smoothly between the parties. Some feel they might be offending the other party by insinuating there's sort of not trust there by having to put it in writing. And it's especially prevalent in family scenarios. But unfortunately, so many people that I deal with, it is a dispute between family members, fathers and sons, falling out, which is so sad to hear, but is very common, unfortunately. And the reality is that those good relationships just don't always continue to be good. So documenting what's been agreed can just protect everyone concerned. And it's much better, as Julie and Tim also touched on, to have to put these agreements in writing but never have to refer to them. Then it's better to do that than to fail to do it and then wish that you had. So it's the age-old better safe than sorry, essentially. And although it's always preferable to have these things documented at the outset, it is never too late to get things formalised. So it's important not to assume that just because something's been happening for a long period of time, for example, that it doesn't need to be put into writing to formalise it, to protect the position. So even if something's been long running, still important to get that in writing now. Also important that it reflects what you've actually agreed. It's not just a case of having any old piece of paper with something written on it. that whatever's in writing needs to be what you have agreed. So, and it's a case of checking what's been put in writing matches what you've agreed face to face, and not just relying on what has been agreed face to face, that will stand if what's in writing is different. So making sure they match is very important. Of course, also important not just to have those written agreements, but to understand them and to seek advice if you're not sure. Both parties need to understand what their rights and responsibilities are, get those clearly documented from the start, so it's easier for all parties to comply and then avoid dispute, as I say. TFA are looking over and advising on these written agreements every day, so it's something I'd be encouraging more members to take advantage of. Sadly, I'm hearing from so many members when it's too late, it's got to the stage where they have relied on a verbal agreement, for example, that hasn't been put in writing, it might not be enforceable. So the earlier members get in touch, the better. Obviously, I would never want to discourage members from getting in touch when they do encounter a problem. That's what we're here for, to help. But it's always better to know what you're dealing with, get that appropriate agreement in place from the start and avoid these problems if at all possible, obviously. So both parties need to understand every stage and element of the agreement. Firstly, the type of agreement that's being entered into, as I say, ensuring it's fit for purpose in the first place. And then during the agreement, as I say, parties need to be clear on what their rights and responsibilities are to avoid breaching that agreement, whether that's inadvertently or otherwise. But lastly, parties also need to be clear on how to bring any agreement to an end. And though I say lastly, it's something they do still need to be clear on from the outset, obviously, ensuring the agreement has the necessary security, but also the necessary flexibility, depending on their individual situation. So I was just going to quickly run through a few examples of where not having a written agreement can cause a problem, these sort of common scenarios where I talk to members about these issues. Again, very much coming from a tenancy perspective, but similar issues could come under contract farming and share farming. So one that's obviously quite big is investment being made without formalising consent under the tenancy. Can have quite big implications for end of tenancy compensation, for example. Both AHA tenancies and FBTs, a landlord isn't obliged to compensate a tenant for fixed equipment that was installed without formal consent. And so often I hear, well, the landlord agreed to it. We stood in the yard, the landlord said, yeah, you can put up that building, you can put that concrete, you can drain those fields. But that isn't enough. That consent needs to be put in writing for that tenant to be entitled to compensation at the end of the tenancy. And another example, not necessarily fixed equipment, but investment in diversification, for example. There might be quite long running diversification enterprises on the holding, so the landlord's well aware that that's happening, quite happy, but if there's nothing in writing having formalised the consent for it, it's not just the compensation at stake, but also the potential for the landlord to withdraw or essentially claim a breach on the fact that they haven't formally consented. There might be other sort of, you can try and prove the intention of the landlord that they've sort of given their consent, implied consent. But if you've got that formal, obvious consent in writing, it's so much easier to prove and avoid that dispute in the first place. So another one is Fbt Renewals is another common example. Notice might be served to end the agreement with a verbal assurance of a renewal, for example. But without that assurance in writing, the tenant can't really rely on that new tenancy being granted. And unfortunately, I've dealt with scenarios where it comes very close to the notice period ending and the landlord changes their mind, there's a fallout, and that tenant hasn't been preparing to leave over the notice period and has nothing in writing to say that they can stay any longer. So I can see the logic from the landlord's point of view. They've served notice in order to then discuss a renewal. It gives them leverage on agreeing the terms of that renewal, but it leaves the tenant so vulnerable without any formal assurance of a renewal until it's actually put in writing. Another final one is rent reviews, not so much the rent itself, landlords being very keen obviously to get any increase agreed in writing, but it's more things that are agreed in return for that rent increase. So if the landlord's agreed to do repairs, for example, or some investment in fixed equipment in return for that rent review, it's so often missed off that rent review agreement and therefore not enforceable down the line. The tenants paying their increased rent but not getting what they agreed for in return. Whereas if it had been put in writing, it would be much easier to enforce. So that's just a few examples, common examples of things that aren't put in writing where it causes issues. I don't think either party should ever be afraid to ask for an agreement in writing. If you're happy to agree it verbally, there should be no reason why you're not happy to put it on paper. And it doesn't need to be a difficult or expensive task, but based on some of the disputes we've come across, it's certainly worthwhile on the basis of sort of a short, just getting anything short, obviously as comprehensive as you can to avoid those disputes, but at least getting something on paper to make it clear what's been agreed between the parties just avoids those disputes down the line. So hopefully that's answered Mr. Skelton's question of a few issues that could arise if you didn't have the agreement in writing, but if it's caused any more questions, then just fire away.
Sorry. Thank you very much, Caroline. That was a very comprehensive run through, and I think the takeaway message from that is, I think Tim alluded to it earlier, that it's easy to avoid putting these agreements together when you think this couldn't possibly happen. But as Tim says, what couldn't possibly happen very often does happen. So it's even more reason to make sure you've dotted I's and crossed T's and got it written down from the start. We have had a few questions come in, so I'm just going to rattle through them. So we'll try and cover as many of the questions. We had a few submitted prior to the event as well, so we'll try and cover as many as we can. I'm conscious we're a little bit short of time. Because we were covering share farming earlier, Duncan Aikenhead asks, there's a few questions in here actually, in share farming, do the participants for shared legal status, e.g. a partnership or limited company, or do they remain separate entities? And also, are the net profits shared 50-50, or is the division of profit calculated differently, and if so, how? So there's a little bit in there, Julie, I think probably for you, that one. And Caroline.
Yep, okay, so very quickly, they remain separate entities. If I just take a typical example, let's just take a potato business, because that's what I've done recently. So we have Smith & Son, one business, and we have Potatoes Limited, another business. Potatoes Limited have the contract, they have the kit. Smith & Son have storage units, they have the irrigation license, they have the land, okay? So both of them are going to do a share farming agreement and farm that unit between them. And we'll have an agreement under which, irrigation is provided, etc., etc. How do we divide profits? We don't get to net profit. We might work up from it in our calculations. We get to the price for the crop. So the crop is going to, the income from that potato crop is going to be shared between the parties. And it might be 60-40, it might be 50-50, depending on what the input costs each of them are bearing. So you're going to work through every item, who's putting in what, and you're going to say, okay, that means you forecast 60-40, the landowner with the storage, the irrigation license is going to get 40, and the one doing all the work and holding the contract and providing the labour is going to get 60% of that crop. And then you will have a schedule which sets out who's bearing what input cost, and you will have an adjustment figure to make sure that it ends up where you want it to be, which is someone's done a kind of net, where we want it to be net. But the key point is that you're sharing that the value of the crop price. Brilliant,
thank you, Julie. Just carrying on the share farming theme, Dennis Matheson, who's our Cymru chairman, asks, says share farming is a good way for older farmers to retire over time and for new entrants to gain access to the industry. However, in a landlord-tenant situation, such opportunities will no doubt require landlord's consent. So that's the first question, I guess. Is there any way that this can be overcome in order to provide the new entrant share farmer with access to the tenancy?
Okay, this is quite difficult. I'll kick off and maybe Tim will come in on that. It is quite difficult, this one. One scenario I can see it happening is where our tenant with a secure tenancy is a limited company, and you can arrange for for the shares in that limited company to be transferred to somebody else, i.e. the share farmer. So that's one model which is rather an easier one to deal with. But otherwise, this is very difficult because share farming involves sharing occupation, and we talked about breaches of the tenancy agreement before. So we could have, it's going to be very difficult unless George and the TFA manage to get that succession law change so that a wider group of people are able, and we know Tenancy Reform Industry Group, we're looking at that, but unless we get that policy change and change in law to allow a wider group, we're pretty stuffed actually on a young contractor from the neighbourhood coming in and being able to succeed to that tenancy and that holding. Okay, I mean, that's the basic position, you know, unless we have two people who can marry each other, that sort of thing, and we get a spouse succession.
Right, okay, thank you. John Hatt probably asked the questions, there's 2 or 3 questions in this, but this kind of moves on to where we're going to be in over the next few years with regard to elms, and it may be a bit early to ask these questions, but we'll try them anyway. The first one being, if I manage fields on an informal annual arrangement to provide public goods, e.g. by, for example, not applying fertilizers and sprays, will I be able to access elms on that land? And often other people who are letting land are reluctant to tie people into long-term leases. So we have short-term leases which don't last the same length of time as at the moment an agri-environment scheme, but potentially an elm scheme. And I suppose the overriding question which comes to mind from while you were talking was, you talked a bit about BPS being included or not. Clearly we're moving away from the BPS environment. I wonder how you see elms and elms agreements starting to be tied into any kind of legal agreement, be it a tenancy, a contract farm, a share farming agreement. It may be too early to answer that, but I'd be interested in your views, really.
Yeah, and also I think it is a policy question, this, because your legal agreements or what you put on your form has, you know, depends on what is allowed in policy terms. And if we can get to 1-year agreements, or if we can get to under the SFI, the new, you know, the first component of the elms, then we might get some flexibility for these shorter informal arrangements for a farmer in those arrangements to be able to tick enough boxes to get a payment. But I don't know if anyone else is there on the policy side, whether Caroline or George, or indeed you, Mark, whether we're likely to see that length of term shortened for certainly the basic component of the scheme, because that's what it depends on.
George, did you want to?
Yeah, I've been sitting in the background listening to the real experts tonight, so it's been quite nice for me just to take that opportunity. But on this point, Julie's absolutely right. There's going to be 3 separate components to the new ELM, and the first component will be the sustainable farming incentive, and it's the intention of DEFRA to allow this to be applied as widely as possible across the farming population, and to try and go for annualized agreements on that, so you're not into multi-annual agreements. The issues that we haven't yet got to the bottom of, though, are who are going to be the eligible individuals. So if you just have the opportunity to graze some land, but the owner of the land is doing the fencing, the hedging, the fertilizing, and all of that, it could be that the owner still retains the right to make the claim under the SFI. So it depends on the extent of your rights under the terms of the agreement. We obviously have been asking for those who take the entrepreneurial risk to be those who have access to the schemes, but all of that is to be developed in real time as we go into next year and into 2022. Obviously, within standard AHA agreements, we have the facility within the Agriculture Act for a tenant to object to a landlord's unreasonable refusal to allow them access to a scheme. So that's helpful within an AHA context. We don't have the same within FBTs, and that's an issue which we're talking to DEFRA about in the live environment, particularly around those who are worried about losing land where the landlord might want to put land into forestry or into rewilding under some of the higher components of the elm. So there's lots to play for here, lots to be discussed, and TFA is very much in the mix with that. And on the 16th of December, for those of you who are in Wales, we're waiting for the white paper from the Welsh government about how they are going to decide to take things forward. So we're having to have these conversations both in the English context and in the Welsh context, but we are certainly live to those issues.
And just to say, Mark, just to jump in quickly, on the long-term farm business tenancies, I've got 3 that I'm juggling at the moment. Long-term, the discussions around the landlord's right to natural capital schemes and discussions around consent needed for agri-environment options, what might affect the reversion of the holding, might not. Remember, trees are usually reserved to the landlord. It's going to be a lot of work for people like me and Tim, actually, because these are difficult issues in landlord-tenant relationships, and the government needs to get it right if it wants particularly the landscape scale, components 2 and 3 to work.
Yeah, I think that's absolutely right, Julie. I think there's a lot of discussion to go on to ensure that everybody who's currently in receipt of a BPS payment is eligible to get ELMs, whether that be an annual or a multi-annual agreement. Obviously, the answer being much longer term tenancies would be a very straightforward way of covering that off, I suspect. I'm very conscious we've slightly run over time here, so I apologise for those questions that we haven't got around to. But what I will do is I will ask Caroline to perhaps respond to the members that have asked the questions that we haven't asked, and email you with some answers on that, if that's all right, Caroline. Sorry to drop you in that one, but
no problem.
Suffice to say, I suppose a very big thank you to all of our speakers tonight, to Linda from GRP for highlighting health and safety and what we all need to do on that. And please go and have a look at the portal she's talking about, and speak to the GRP group or anybody at the TFA office about insurance. Massive thank you to Tim and Julie for covering a big whistle-stop tour, I think, of contract farming, share farming, and lots of other things in between. And as I said earlier, I think this just highlights really how important it is to look at your agreement. You know, things are going to change. We may not like it. We may embrace it. It's better to embrace it probably, but we need to be in the right position to go forward. And Julie's point at the end there about there being a lot to play for, and agreements are complex in this arena and are likely to be under ELMs, I suspect. And also a big thank you to Caroline for your input as ever, and just reiterating to everybody, that having something in writing is absolutely worth the paper it's written on. It's all very easy to have a good relationship with somebody who then moves on, doesn't any longer work for the landlord or the agent, and you can remember that was a nice agreement, and suddenly someone else has come in or a new generation has come in and there's nothing in writing, and that relationship has folded. So really, really important. So a massive thank you to everybody. Big thank you to Julia, sorry, for organising the webinar, to everybody for attending, and a huge thank you as ever to Barclays for sponsoring this. I ought to know when the next one is. I don't, but keep your eye on the TFA news for news of when that comes, I think after New Year. So thank you all very much for attending. Have a great Christmas. It's nearly that time already. I think the best thing will be to get to the 31st of December and 2020 behind us for a whole range of reasons, and hope that 2021 is a little bit more positive. So thank you all, and I'll let you go and enjoy your evenings.